Thank you so much for your support. And if you're wondering, my name is Grant Smith Ellis. I'm hanging out with you. I made the letter as large as I can make it. And let's take a look at the new letter from US Attorney Leah Foley's office released in the context of the Brian Walshe case. It is a letter from U.S. Attorney Leah Foley's office to First Assistant Lisa Beatty of the Norfolk County District Attorney's Office. And the letter talks about, and it really requires some context. Remember, I'm not a lawyer. I'm not your lawyer. I am a towel. None of this is legal advice. But it really requires some context to understand because it's like a speaking letter, and it's a letter that has a lot of odd undertones to it. I read it a few minutes ago, so I understand what it's talking about. And in general, what the letter says is, in order to effectuate the prosecution or help the Norfolk DA prosecute the cases involving Brian Walshe and some of the other criminals because of the, quote, serious nature of the charges, in order to facilitate compliance with Rule 14 discovery obligations, the the U.S. Attorney's Office under 28 CFR 26.1 is going to facilitate the release. Personally, U.S. Attorney Leah Foley is going to facilitate the release of documents related to Michael Proctor from the now confirmed as closed federal probe into John O'Keefe's death. However, what the letter also then goes on to say is what they will not give, what the U.S. Attorney's Office will not give, and by the way, this letter confirms that the probe of John O'Keefe's death by the federal government is over in the last page. We'll get there. But what they're not going to give over, says U.S. Attorney Leah Foley, is they're not going to give over material from Michael Proctor's grand jury testimony, the federal grand jury testimony. Now, they give two reasons for it. One, it would violate federal law for the U.S. Attorney's Office to do that. And then, second of all, they argue that it's redundant because Michael Proctor testified under oath in Reed's first trial, so therefore all of these defendants seeking Michael Proctor's grand jury testimony don't really need it. Third, the U.S. Attorney's Office states that the only material in Michael Proctor's grand jury testimony relates to the Reed case, if that testimony even exists. They're being a little wishy-washy about how they talk about it. So therefore, there's no grounds for them to release it to any of these other defendants, the Brian Walshe defense, or some of these other defendants. And then furthermore, the U.S. Attorney's Office says that the other defendants have no standing to intervene in the protective order that currently exists related to the Reed case material via federal court. And therefore, two things follow from that. One, if a state court issues an order compelling the Norfolk District Attorney's Office or the U.S. Attorney's Office to turn over protected federal grand jury material related to Michael Proctor, then the U.S. Attorney's Office will move under the relevant section of the law that I just referenced to move the matter to federal court. That is basically a message telegraphing to all the defense attorneys, don't do that, and none of them are going to do it, because it will get immediately removed to federal court for the purposes of confirming that the state court order attempting to provide Michael Proctor's grand jury testimony to the feds would violate federal law, and so they could get the federal court by the U.S. Attorney's Office removing the matter to federal court could basically quash the order to compel production of the federal grand jury material. Furthermore, the U.S. Attorney's Office also says in this letter with regards to that grand jury material, if a party is aggrieved by the release or by what U.S. Attorney Foley's office chose to release under 28 CFR 26.1, then the appropriate remedy is for them to file a TUI request. Okay, this isn't being released pursuant to a TUI request, which is enumerated under Section 25 of the DOJ Operations and Sections Manual, which is itself an interpolation of U.S. Ex Rel. TUI v. Reagan from 1985. Now, this has to do with what happens if parties to a state court criminal case want to obtain documents from a federal court, a federal investigation that's ongoing, in the context of discovery obligations, for example, due to the defendant in the state court case. So, as such, U.S. Attorney Foley's office concludes the letter by saying, well, basically, you have a remedy at law here, the defendants, attorneys in some of these other cases, Brian Walshe and others. You have a remedy at law here, which is you can invoke the Administrative Procedures Act after filing in due course and appropriately a TUI request under U.S. Ex Rel. TUI v. Reagan, And then if that TUI request is insufficient or inappropriate, then you can appeal it under the Administrative Procedures Act in federal court. What you can't do is try to do an end run around US Ex Rel. TUI v. Reagan by getting a state court to compel production of the grand jury material, the federal grand jury material involving Michael Proctor. And then you also don't have standing to intervene at the U.S. District Court in Boston to get the protective order either amended in scope or changed. And the U.S. Attorney's Office isn't going to accede to the request by these defense attorneys to move to amend the scope of that still ongoing protective order, even though the Reed and O'Keefe federal probe is over, in order to facilitate the transference of these federal grand jury materials. So how do you interpret all this? We're going to read it, but I already read it, so I just told you what it says in lay English, basically. So how do you interpret all this? Well, basically what it means is that the U.S. Attorney's Office doesn't want any of these defendants, these state defendants, Brian Walshe and others, to be able to get away with what they did because Michael Proctor has this bad reputation, and so the U.S. Attorney's Office is going overboard to facilitate reciprocal discovery compliance by the Norfolk County District Attorney's Office to ensure those cases can't be dismissed on procedural grounds or whatnot due to failure to comply with discovery obligations. But the U.S. Attorney's Office is then foreclosing the ability of those defendants to argue that the absence of the Proctor federal grand jury testimony justifies dismissal of their state court cases by layering into this letter a bunch of stuff that basically makes it clear that there's nothing in there that's going to help those defendants. And furthermore, if they move to try to get these materials at all through any process other than the TUI process and or an appeal via the Administrative Procedures Act, the U.S. Attorney's Office is going to rain all hell down on them by removing the case to federal court if there's a state court order compelling production of those federal grand jury materials. Does that all make sense, ladies and gentlemen? So that, yes, Selma, it was great to see you. Glad you were able to pop in. But that's what we're dealing with. Let me pull out my telephone in case you have any questions. I'm going to read the letter for you in full, but that's what the letter means in lay English, in my opinion. You really have to know what you're reading to understand it. You have to be an expert, for example, in US Ex Rel. TUI v. Reagan and things along those lines. So in order for you to do that, ladies and gentlemen, what I suggest is that you listen to the explanation that I just gave, and then as I pull up the comments here, give me 1 second. I want to be able to watch along with you. I want to watch my stream. There it is. I want to be able to read along with your comments because this is not the easiest thing in the world to understand. So if you're just tuning in, we're going to go over the letter. I just gave you what's called a primer. All right, so a primer is an introduction to that kind of thing. The trial is an introduction to that kind of thing. So, actually, let me be very clear. Somebody was getting upset at me. Sorry, somebody trolled me. They were getting upset because Kate Peter got caught doing something bad, so I had to block them. I'm not going to let you distract me right now, by the way. So the block button, not in the comments, it was on Facebook. The block button is my best friend right now. So we're going to talk about this. And by the way, the work that I do, this is a public information service, and, you know, for example, I try to help in different ways. That doesn't mean I always talk about it, but this is first and foremost a public information service. So God bless each and every single one of you for supporting this public information service. Thank you very much. My name is Grant Smith Ellis. Thank you for tuning in with me today. No matter what slings and arrows people throw at me for doing this work, I don't care what coverage we're talking about. I don't care what interests are involved that get frustrated about it. I'm going to keep doing it because my commitment is first and foremost to the people who are interested in the power of cogent public discourse to ward off the usurpation of our representative forms of government. So, all right. I should not read people trolling me on Facebook. All right. Here we go. Dear First Assistant Beatty, as you are aware, in response to a joint TUI request by the parties to Commonwealth v. Karen Reed, docket number 2282, CR0117, Norfolk Superior Court, my office, this is from U.S. Attorney Leah Foley's office, it's the first assistant, or not the first assistant, it's an assistant U.S. attorney who writes the letter. My office produced certain federal records, the quote confidential materials, to the parties in that matter. Now, when they use confidential materials, that, like, see how it has two quotations there? What they're saying is that's referring to what's in the immediate sentence before, certain federal records, okay, which will hereafter be called the confidential materials, to parties in that matter. The confidential materials are subject to a protective order issued by the U.S. District Court for the District of Massachusetts, and that order provides the parties to destroy those records upon completion of the Reed matter. As you are aware, the trials in that matter, including testimony regarding communications about the defendant, Karen Reed, by now former Massachusetts State Trooper Michael Proctor. You have advised my office that the Norfolk County District Attorney's Office is prosecuting other cases Proctor investigated, quote, other matters. Because the protective order only permits the parties to use the confidential material in the Reed matter, and you believe that the Norfolk County District Attorney's Office may have discovery obligations under state law to produce some of the confidential materials in the other matter, you have asked my office to seek an amendment to the protective order to allow, 1, the Norfolk County District Attorney's Office to produce from the confidential materials any statements by Proctor to the defendants and their counsel in the other matters, and 2, so like the Walshe case, etc., 2, assisted district attorneys prosecuting the other matters to sign the protective order, review the entirety of the confidential materials, and produce any other of the confidential materials to the defendants and their counsels in these other matters that the Norfolk County District Attorney's Office would be required to produce under the Norfolk County District Attorney's Office criminal discovery obligations. Okay, so there you go, ladies and gentlemen. You can see what the Norfolk County District Attorney's Office, which was asking for basically in response to prodding from the defense attorneys in those other matters investigated by Proctor. And so that is what the U.S. Attorney's Office is responding to. It's a letter to the Norfolk County District Attorney's Office in the context of the Norfolk DA being able to comply with their discovery obligations under Rule 14 in these other criminal cases that Proctor investigated. Now, please note here, this was sent on August 5th, 2025, so this is recent. We're only talking 2 weeks ago. And in the world of letters from the federal government or to the federal government that are by officials, this is a quick release. It came out in Discovery, I think. Dee Dee posted it over on Twitter, and I reposted it. It is serious, folks. So, pursuant to 28 CFR 1621C, which permits the United States to produce federal records to any law enforcement agency in the absence of a TUI request. Now, so do you see what this, it's actually 1621C. I said 16.1C earlier or whatever it was. It's 28 CFR 16.21C. I might have said 21.1C or whatever. So, pursuant to 28 CFR 16.21C, which permits the United States to produce federal records to any law enforcement agency in the absence of a TUI request. So remember, the Norfolk DA is a law enforcement agency. What this is saying here is U.S. Attorney Leah Foley, and if you read 28 CFR 1621, it does say this, okay? We've shepherdized this before. I'm not a lawyer. This is not legal advice. But if you read it, and we can take a look at this. So let me just show you what U.S. Attorney Foley's talking about here, okay? So I think it is appropriate to at least make some contextual sense. So let me bring up the 28 CFR 1621, okay? I'm going to bring 28 CFR 16.21, all right? So we're going to take a look at this part, and I'd like to get it from the DOJ themselves. Yep. All right. Hold on. Yeah, the Gov site is fine. All right. So here's the relevant law that we're talking about. All right. Before U.S. Attorney Leah Foley's office starts going into it, let's take a look. All right. So there we are. We're taking a look at 1621. All right. And we're looking at specifically C. All right, so the real premise of this is this subpart sets forth procedures to be followed with respect to the production or disclosure of any material contained in the files of the Department of Justice, any information relating to materials contained in the files of the Department, or any information acquired by any person while such person was an employee of the Department of Justice as a part of the performance of that person's official duties or because of that person's official status. In all federal and state proceedings in which the U.S. is a party, and in all federal and state proceedings in which the U.S. is not a party, including any proceedings in which the DOJ is representing a government employee, solely an employees of individual capacity, when a subpoena, order, or other demand, hereafter referred to as a demand, of a court or other authority is issued for such material information. And then B, for purposes of this subpart, the term employee of the DOJ includes all officers, etc. Now, this is the relevant part. Nothing in this subpart is intended to impede the appropriate disclosure in the absence of a demand of information by the department law enforcement agencies to federal, state, local, and foreign law enforcement, prosecutive, or regulatory agencies. So this is where it comes from. Remember when U.S. Attorney Leah Foley went on Dan Ray's Nightside and said that she couldn't confirm or deny the end of the federal probe into John's death, but that it was routine for federal DOJ authorities to release to state and local law enforcement partners that certain information about investigations? This is it. Unprompted, without a TUI request, nothing in this subpart is intended to impede the appropriate disclosure in the absence of a demand, a TUI demand, of information by the department, law enforcement agencies to federal, state, local, and foreign law enforcement, prosecutive, or regulatory agencies. So basically, the U.S. Attorney Leah Foley's office is saying, you don't even have to submit me a TUI request. I'm just going to give you this material, some of this material, pursuant to my authority under that section of the federal regulations. That's what that sentence is referring to. So now take a look at where the sentence goes from here, okay? So pursuant to 28 CFR 1621C, which permits the United States to produce federal records to any law enforcement agency in the absence of a TUI request, I am producing to the Norfolk County District Attorney's Office all of the Proctor communications previously produced as part of the confidential materials. Now, you would say, okay, that's everything, but it's not. It's like 98%, because listen to where it goes. Given these records are produced pursuant to 1621C, they are not subject to the protective order, right? So there's the protective order from the district court in Boston. U.S. Attorney Leah Foley's kind of doing an end run around in an authorized way to release certain material that is simultaneously subject to the protective order, but now also being released in line with federal law and the existing protective order under 16.21C, which gives U.S. Attorney Foley's office, although I'm pretty sure it has to go like all the way up the chain to Main Justice in D.C., the authority to unilaterally disclose certain information, notwithstanding an existing federal protective order under 16.21C. Everyone following along here? It's very convoluted, but if you know what you're reading, it makes a lot of sense. All right, so here's where we're going next. Given these records are produced pursuant to 1621C, they are not subject to the protective order, and the Norfolk County District Attorney's Office can use them as appropriate in the other matters. So the Norfolk County District Attorney's Office, to comply with Rule 14, this is what it's saying in other words, can release these matters now because even though they're subject to the protective order, because U.S. Attorney Leah Foley's office released them under 16.21C, they can be used in those other criminal cases. As you will see, most of these statements are already reflected in the Reed trial record, and none appear to concern defendants in the other matter. So that's the judges in those cases are going to be like, okay, so it doesn't even pass. There's two standards for relevancy, okay, 401 and 403. This doesn't pass the basic relevancy analysis under 401, not to mention getting to the probative value or sort of the balancing test under 403 relative to the relevance balanced against the prejudicial impact, or we don't even get to step 2 of the analysis. Just under the basic relevancy test, this statement from the U.S. Attorney's Office renders all of these arguments, whoever that lawyer was, Rosemary or Walsh's lawyers, it just kneecaps them. And this is a tactical kneecap by the U.S. Attorney's Office, who clearly does not like criminals, because this office is kneecapping all of these defendants, all right? Notwithstanding what Proctor did. The U.S. Attorney's Office right here is being like, don't even try. Nothing in there is relevant. We're putting this on record, sending it to the Norfolk DA, who's going to turn it over to the judge in discovery. Don't even try. And they're telegraphing, and watch, it gets way more brutal in the end of the letter, but they're telegraphing to these defense lawyers, don't do it. Don't do it. And you can sense, like, I didn't know this was coming, but I could have told you before I even read the letter, that's exactly the position this office would have taken, in my opinion. I don't know them, I don't talk to them, not that office, but what I'm saying is that's the way, in my opinion, that you would directly start this letter. Okay, you would basically say, listen, we're going to turn this over. And what you're doing is you're not helping the defendants. The letter says right there, there's nothing in these statements about any of those cases. They're doing it so the defendants in the other matters can't use it as pretextual, apparitions to try to get their cases dismissed or cause public furor. I think this was a response to that Rosemary, or whoever that lawyer was representing some of the other Proctor defendants. They were making a lot of noise, okay, but this is the U.S. Attorney's Office saying, well, make your noise about some of the other stuff, the search warrants that Proctor was withholding from Lally, whatever. But don't make it about the federal probe, or we're going to come down and crush you. And that's exactly what this letter goes on to say. So, here we go a little bit more. Let me see if I missed any questions. But anyway, so just to focus more on this letter. All right, so we get to the next part of the letter where it says that, as you will see, and this is a letter to the Norfolk County DA's office, but it's really to the defense attorneys. As you will see, because remember, it's the Norfolk DA who has the discovery obligations under Rule 14 that could cause, if they don't fulfill them, the defendants to get the case thrown out. And the DOJ here is favoring the Norfolk County District Attorney's Office and saying, like, no, those defendants are not leveraging Proctor's involvement with the now confirmed as closed federal probe into John's death to get their cases dismissed or anything like that. That's what this is. And so to continue analyzing this, as you will see, most of these statements already are reflected in the retrial record, and none appear to concern defendants in the other matters. My office is nevertheless producing them to facilitate the Norfolk County District Attorney's Office prosecution of the other matters. It doesn't say so they can comply with Rule 14 and the defendants can't make the argument to get the case thrown out, but that's what that sentence means. Okay? Now, next paragraph. To the extent the confidential materials contain federal grand jury, this is the caveat. And you can tell here that this is not, like, there's a limitation under 16.21c, and it either has to be due to the interpretation of 16.21c or its precursor language by the court in US Ex Rel 2 v. Reagan in 85, or it has to do with, like, the U.S. Justice Department Operations Manual and Section 25 of that manual in particular, and there must be a balancing of authority related to the disclosure of non-federal grand jury material and grand jury material pursuant to 1621c, which tells me that the protections for federal grand jury material are stronger than the unitary authority of the DOJ and the U.S. Attorney's offices throughout the country and in Washington to disclose material unilaterally pursuant to 1621c. That is some serious stuff, and it makes sense because grand jury testimony is actually being taken in the name of the court. The grand jurors are charged in the name of the court. That's also why what Jessica Leslie did, the grand juror leaker related to these cases, was such a big deal, little towels. All right, so do we understand where this is all going? U.S. Attorney Leah Foley under 16.21c can release a bunch of confidential material from the now confirmed as closed federal probe into John O'Keefe's death. But what U.S. Attorney Leah Foley cannot do, even under 16.21c, is release protected federal grand jury material. So here's where this comes up. Now watch how circumspect this letter is just about that federal grand jury material. To the extent the confidential materials contain federal grand jury testimony by Proctor, and without confirming or denying that such testimony exists or was among the confidential material, I roll my eyes at that, but I loved it. My office would be prohibited by federal law from disclosing that testimony for use in the other matters absent a court order. Now, that would say, okay, so they'll just get a state court order. No, listen to where they go from there. Moreover, my office would not have a sufficient basis to move the U.S. District Court for a disclosure order under the circumstances. Remember, we're talking, they disclose the other non-grand jury stuff, but the federal grand jury stuff from Proctor, they won't even admit exists. And if it does exist, they're not turning it over. And here's, not only are they not turning it over, they won't go to federal court. The U.S. Attorney's Office won't go to federal court to amend the scope of the existing protective order to facilitate the transference of this grand jury material. Now, here's where we go next. Moreover, My office would not have a sufficient basis to move the U.S. District Court for a disclosure order under the circumstances. My office's investigation pertained to the circumstances underlying the Reed matter, and therefore any grand jury testimony by Proctor in the confidential materials would not have addressed the other matters. That means, according to this, there is nothing related to the other matters, the other criminal defendants that were investigated by Proctor, nothing that he was asked about in his grand jury testimony. And in fact, it says the office pertained, the investigation of the Reed, O'Keefe and Reed probe pertained to the circumstances underlying the Reed matter, and therefore, and it doesn't say only, but it says to the circumstances, and therefore any grand jury testimony by Proctor in the confidential materials would not have addressed the other matters. So that's just another reason under the relevancy test to say, first of all, you're not getting this material, and second of all, it's not relevant to you 6 defendants, so you're not getting it. Let's see. Yes, Michael Proctor is trying to get his job back. He has a public hearing in front of the Civil Service Commission on August 27th. All right, next question. Next question, I thought we were playing trivia. Now, furthermore, assuming arguendo, which means they say, assuming arguendo, for argument's sake, that the confidential materials contain, I want him to say arguendo, come on. Arguendo, like, let's set the standard. That office wanted to say it. It must be like a little too formal. They would say arguendo in a motion, maybe not in a letter. But furthermore, assuming for argument's sake, which the Latin phrase for that is arguendo. Furthermore, assuming for argument's sake, and they know that, they probably wrote arguendo there first, but then someone was like, well, it's a little too formal. That's my opinion. They're very smart at that office, I believe. Furthermore, assuming for argument's sake that the confidential materials contain Proctor's grand jury testimony, Proctor testified at the first trial in the Reed matter and would have been subject to impeachment with that grand jury testimony. The trial testimony from the Reed matter, therefore, would be more than a sufficient alternative to assess Proctor's bias. It's the least It's like the least burdensome alternative means if they don't want to disclose it. And so what the U.S. people misunderstood this on Dee Dee's Twitter feed. I saw a few people misunderstanding this. What this is saying is that, and it's really weird that they're doing this, but they're saying basically like, listen, Proctor testified in the Reed case. Reed's lawyers, Alan Jackson and David Yannetti, had access, and it was the first one. So Alan Jackson, David Yannetti, and Eliza Little, and Tanis Yannetti, okay? First trial. They had access to that confidential material. They could have used it to impeach Proctor, and therefore, because Proctor was subject to cross-examination when he testified at the state court trial, and incorporated by reference into that cross-examination was the fact that David Yannetti, Eliza Little, and Alan Jackson and Tanis Yannetti had access to the federal grand jury material related to Proctor. That is a sufficient basis for Proctor's state court testimony in the Reed case standing alone to serve as sufficient purposes for any potential further impeachment needs of the 6 defendants who are moving to try to get the grand jury testimony. It's a wild structure, but it's great. I mean, that's the right analysis. But what it's basically saying is, if Alan Jackson and David Yannetti and Tanis Yannetti and Eliza Little didn't have access to those documents, then maybe Proctor's testimony during the first trial wouldn't be enough to argue that that is a sufficient alternative grounds upon which these 6 defendants can pursue impeachment against Proctor, like impeachment of his testimony in their cases. But because Yannetti and Jackson and Little and Tanis Yannetti did have access to the federal records, it is enough to say that because Proctor testified in the Reed case, anything you need to impeach him on, you can get from the state court testimony. It's brilliant, and it's undercutting the arguments of the defense attorneys in the other matters, the Walshe case and otherwise, who might want to get that material. It's brilliant, all right? They're undercutting them tactically at every step. They're basically saying, don't even bother motioning the courts about this. We're just going to run you over with this stuff. We're going to absolutely bury you in federal law and process, and we're right, and we have all the power. That's what this letter is saying. It's not saying it to the Norfolk DA. It's actually helping the Norfolk DA's office, perhaps begrudgingly. Well, I also wonder if the feds forced the Norfolk DA's office to clean up that MSP unit, like Tully and John Fanning and, Yuri Buchanan and whatever. I wonder if the feds force them to clean it up. That kind of makes me think that this makes a lot more sense to me now. Like, it's not that the feds don't like Michael Morrissey right now. It's that they didn't like that unit. I don't think they like Karen Reed, the current DOJ. I don't think they like Jessica Leslie. I don't think, well, they're protecting her, I think, but I don't think they like Karen Reed or Turtle Boy or Alan Jackson or David Yannetti. I don't think they like Kate Peter or Brian Tully or Marty Kraft or Yuri Buchanan or John Fanning or Nick Garino. All right. And so that's why I think there's apoplectic levels of chaos right now, because the reality is the only people who got out of this unscathed were the Norfolk DA and Hank Brennan. Okay, and I truly believe, although I can't confirm this and have spoken to the man other than when he told me I could call him Hank, I truly believe that Hank Brennan negotiated a deal wherein the Norfolk County District Attorney's Office gave up his own guys, the Norfolk County DA, Michael Morrissey, gave up his own guys related to the Birchmore cover-up. And I have real reason to believe this because in August of 2024, when Michael Morrissey found out that Farwell got indicted for Sandra Birchmore's murder under 28 U.S.C. 1853, murder of a cooperating federal witness, Michael Morrissey sent Brian Tully and John Fanning an email saying, "Is this true?" Which means Morrissey, from the very minute he found out Farwell got federally indicted, was ready to give up Tully and Fanning. Tully and Fanning were partners for like 20 years. Remember, Sandra Birchmore was the woman who got murdered by a former Stoughton cop, allegedly, Matthew Farwell. And Farwell used to work in Stoughton as a police officer, where two of these members of Morrissey's state police unit, John Fanning and Yuri Buchanan, used to work. Now, you might be saying to yourself, Grant, this is a lot to keep track of. Is there any way maybe you can give us a chart? Yes, I just have charts just waiting to bring up. You know what I'm saying? Like, I just have a chart. That's the chart. You see the chart? That's the chart. Have you not seen the chart before? That's the chart. All right, that's the chart, ladies and gentlemen. It is not just a chart, it is the chart to end all charts. That explains everything. All right, it even involves Lindsay Gattani's unredacted phone extraction being released by the same MSP unit. It wasn't just that Aidan Kearney, Josh Levy, Rachel Rollins, David Yannetti, Karen Reed, Alan Jackson, and others did bad things involving leaking protected grand jury information, in my opinion, and using it to weaponize public perception around Reed's case in order to poison the jury pool. It's also that the Norfolk DA CPAC unit, in my opinion, covered up Sandra Birchmore's murder and then worked with Kate Peter to investigate Aidan Kearney and Karen Reed, which involved leaking Lindsay Gattani's unredacted cell phone production under color of law, which was also a bad thing that Brian Tully did. And so therefore, I believe Hank Brennan negotiated some kind of weird deal where the Norfolk DA gave up his own CPAC unit, the MSP unit that used to work for him under former Commander Brian Tully, related to all of this. And that's why we see this weird tone. Okay, this really weird tone in this letter. It's like it's a letter that helps the Norfolk DA, but yet you have Kate Peter threatening the Norfolk DA on Twitter over recent weeks, and it's pretty clear why. The Norfolk DA, Michael Morrissey, is clearly on good terms with the feds, but Kate Peter, Brian Tully, and the other folks involved with the Birchmore stuff, the Lindsay Gattani stuff, whatever, got thrown to the wolves, as did all the people involved with Jessica Leslie's leaks, because Rachel Rollins and Josh Levy are out of power at the DOJ now. That's why the Free Karen Reed movement is in freaking apoplectic chaos as well. So you got people around Kate Peter and Marty Kraft and Brian Tully literally melting down because they have no protection anymore from the Norfolk DA's office. And then you got Aidan Kearney and Karen Reed and all their people freaking out because they have no protection from the DOJ anymore, because Rollins and Levy are also in the crosshairs of the federal investigators, in my opinion. It's freaking apoplectic levels of chaos, and this letter spells it out. I mean, a lot of people, I don't think they understand how to read these letters, and I'm not being pejorative. I'm not a lawyer. This is not legal advice. But these are letters where it's like a lot of the language is not direct. Like, you have to infer based on what the letter is accomplishing tactically and the tone it's taking and the posture it's taking, who they're supporting and why and what their ends are. And the ends of the U.S. Attorney's Office in this letter are very clear. They want these cases prosecuted. They don't see a problem cooperating with the Norfolk District Attorney's Office, and they don't want these defendants weaponizing specters and apparitions to induce artificial reasonable doubt at the expense of the fact that there was a federal investigation of John O'Keefe's death and that MSP unit related to Tully and Proctor, not in the context of the Reed probe and O'Keefe probe, but at least in the context of Birchmore and then the Turtle Boy stuff and the Lindsay leak, was weird. All right? Like, the feds are basically saying, okay, we're all right with the Norfolk DA, but they don't say it in this letter, but like the tone of this letter coupled with developments over the past few weeks reaffirms a lot of what I've been thinking, which is that Hank Brennan and Leah Foley have been the adults in the room the whole time since January of 2025 and figured out some kind of like way to solve all this chaos and protect the justice system, and they're just not talking about it fully yet. That's what I believe is going on. So, as a result, and I just really want to narrow in on this, what this letter is saying, and it's going to become more and more clear here, is that the U.S. Attorney's Office wants these people convicted. They don't want them using the defendants using Proctor. The U.S. Attorney's Office doesn't appear to want these defendants using Proctor as a shield to avoid conviction. Well, that's a weird position to take, right? Like, so that means you must have felt that way about the Reed case. But we didn't see this kind of intervention, right? We saw it a little bit before the Reed case, but it was very mild. Confirmation of the end of the probe through the Canton PD and the Norfolk DA's office, etc. But, it wasn't like this. It didn't tip their hand. So why not do that? Why let the public in the jury pool, why not let them on to this a lot earlier? I think I know, because I was right, and that probe of that second trial was a honeypot. It was a 100% honeypot. It was a honeypot to catch Turtle Boy and Karen trying to interfere with the state court jury, and I bet they did catch him. This DOJ wanted to get Karen. I think they still do. I think they really want to get her. She killed a cop, allegedly, in the civil suit. Allegedly. They want to get her. She killed a cop. Like, you put your hands on a cop right now, the DOJ will rain hell down on you. She allegedly killed a cop. So, I think they want to get her. And I think if you read into this letter, like, inductively, the posture of the U.S. Attorney's Office, they want to get Karen Reed just as bad as they want Michael Walshe to be held accountable and some of these other folks. This is incredible. I mean, the tone of it is so, it's interesting, because I feel like the one thing that throws a wrench into all of this is they're not afraid to charge cops, the DOJ, but I don't think they want the public to have the perception that cops are dirty. The DOJ seems to want to support prosecutions of criminals while also making an example of like bad cops and bad prosecutors and bad sheriffs, especially if they're Democrats. Now, there's something larger bubbling up here too. The DOJ just sent a letter to Mayor Michelle Wu in Boston that led Wu to have like this firm press conference today targeting the federal government. One second. Hello, I'm back. Sorry about that. This is one of those days. If you get certain kind of calls on a certain kind of day, you got to answer it. All right, so let's pay attention. Well, I'm so sorry about having to go away there for a second, but this is one of those days. All right, so let's continue reading this letter. If you're just tuning in, what we were talking about is why the nature of this letter is so insightful, okay? And the reason why it's insightful is it talks a little bit about it gives you hints into what the U.S. Attorney's Office is thinking. And what the U.S. Attorney's Office is thinking is they don't want people repeating what Karen Reed did. They don't want the defendants putting out these apparitions like innocence of innocence that are not real, okay, for the purposes of subverting public perception and poisoning the jury pool. And this is how they're putting a stop to it. That's my read of it. So let's get back to the letter. We were just getting into the part of the letter where the U.S. Attorney's Office is asserting the grounds for why there are alternative remedies for disclosure that do not require, alternative remedies for impeaching Proctor that do not involve giving over this grand jury material, all right? And the biggest argument was, listen, Proctor was subject to cross-examination by people who had access to those federally protected grand jury material in the first Reed trial. Therefore, whatever that record is from the state trial, the questions are sufficient and an alternative to Proctor to the feds disclosing the grand jury information, because the defendants in the 6 other cases, the Walshe case, the other cases, can just use that Proctor cross-examination as grounds to impeach him if they need to. It's brilliant. Finally, okay, so hold on. So that was the sentence. Furthermore, assuming arguendo that the confidential materials contained Proctor's grand jury testimony, he testified at the first trial in the Reed matter and would have been subject to impeachment with the grand jury testimony. The trial testimony from the Reed matter, therefore, would be more than a sufficient alternative to assess Proctor's bias. Finally, any grand jury testimony by Proctor would be cumulative of other sources of evidence of Proctor's bias as to Ms. Reed already available to the defendants in the other matters, the Walshe, etc., including the extensive trial record in the Reed matter, the Massachusetts state disciplinary proceedings against Proctor, and all statements produced with this letter. Similarly, my office will not seek a further amendment of the protective order at the U.S. Federal District Court to allow ADAs prosecuting the other matters to review the entirety of the confidential materials for potentially discoverable information. Now, remind you, it may seem like they're saying the Norfolk DA's office can't do this, but they already let the Norfolk DA's prosecutors do this in the Reed case. What they're saying is they're not going to seek federal court permission to allow those other ADAs to look at these materials for the purposes of facilitating compliance with discovery obligations. And the reason why is for the reasons just laid out, which is there's nothing in there that's discoverable really for those other matters. And so they're not going to do this, and they're not going to move at the request of basically the defendants in those other matters to go to the federal district court. Even though it seems like it's a request coming from the Norfolk DA's office, really it's a request from the Norfolk DA's office to facilitate discovery compliance, and it's coming from the defendants, Brian Walshe, etc. And so here we go. There is no reason why, there's no reason why the non-Proctor records within the confidential materials would be relevant to the other matters, given the scope of my office's investigation. Hold on. Similarly, I have to reread this. Similarly, my office will not seek a further amendment of the protective order to allow ADAs prosecuting the other matters to review the entirety of the confidential materials for potentially discoverable information. Oh, I get it. So Leah Foley, U.S. Attorney Leah Foley's office is saying, I'll turn over what I feel comfortable with under 1621C. I'm not turning over stuff under that's protected federal grand jury information, and then I'm not turning over certain other stuff. All right. Basically, U.S. Attorney Leah Foley's office is saying we'll release some stuff to you. It's not really relevant to your case, but we're not giving you the whole record. And furthermore, we're not letting the DAs in those other matters, the ADAs, go through the material and have them decide what's discoverable. We've decided under 1621C. That's the end of it. So that's what that says. There is no reason why the non-Proctor records in the confidential materials from the Reed case, is what that's saying, within the confidential materials would be relevant to the other matters, given the scope of my office's investigation, which is in the TUI records from the Reed case. It's talking about just that investigation, not anything else, not Birchmore, not CDL, not anything else, just the summer 2023 and February 2024 investigation into John O'Keefe's death, federal, okay? There is no reason why the non-Proctor records within the confidential material would be relevant to the other matters, given the scope of U.S. Attorney Leah Foley's office's investigation. As mentioned previously, U.S. Attorney Leah Foley's office's investigation focused on the circumstances, and this is that one investigation that produced TUI records for the Reed case, focused on the circumstances underlying the Reed matter. Because remember, we're only talking about the confidential materials turned over to the Reed defense and prosecutors in the TUI request related to the Reed case. Okay, so it's not even touching on other investigations. As mentioned previously, my office's investigation focused on the circumstances underlying the Reed matter, and the confidential materials included here only those materials from that investigation that were highly relevant to that matter. We, so her office, accordingly have no basis to believe that there is anything else relevant to the other matters, which means the Walshe matter or any of the other defendants investigated by Proctor, in the confidential materials, which is just the TUI response sent to the Reed and defense and Reed prosecutors. Further, supporting this position, besides Proctor's statements, the Norfolk County District Attorney's Office and Defense Counsel in the other matters, so in like the Walshe case, have not identified any documents or categories of documents that might be included in the confidential materials from the Reed case that are relevant to the other matters, the Walshe case, etc., despite many of the confidential materials being referenced during the public proceedings in the Reed matter. Nor would it be appropriate for U.S. Attorney Leah Foley's office, the Norfolk County District Attorney's Office, or any defendant to comb through the confidential materials on the mere possibility that such relevant information might exist. My office appreciates the concerns of the Norfolk County District Attorney's Office, Defense Counsel in the other matters, Walshe, etc., and the state judges presiding over the other matters. My office, U.S. Attorney Leah Foley's office, is keenly aware of the seriousness of the charges in some of the other matters and wishes to see that justice is done. So this is an anti-defense position. Now, Rachel Rollins and Josh Levy would not have taken the position. Court is back in session. We're almost done with the letter. My office is keenly aware of the seriousness of the charges in some of the other matters and wishes to see that justice is done. This response, I believe, does that while balancing the United States interest and compliance with federal law. Given this response and the fact that the Reed matter has concluded, there you go, confirmation, federal probe into the Reed case, over, boom, there it is, in writing. Take it home, take it to the bank, seal it and deliver it, make a cake, put it in the sky, fly a plane, tell Turtle Boy about it. Given the fact that the Reed matter has concluded, there it is, and it could also be the state matter. But either way, they also confirmed that the Reed federal probe was closed 3 times in this letter. So given this response and the fact that the Reed matter, which I think might be the state matter, but either way, if you didn't see it above, it confirmed that the Reed matter, the federal probe, is closed as well. Given the response and the fact that the Reed matter is concluded, the U.S. requests that the Norfolk County District Attorney's Office comply with the protective order, the existing protective order, and destroy its copies of the confidential materials according to the deadline set in the U.S. District Court's July 21st, 2025 order. So I think it was August 21st, 2025. They gave him 30 days. So those records are getting destroyed 2 days from now. I nevertheless want to make 2 points that I hope will guide the Norfolk County District Attorney's Office decisions about future action. First, given that the federal court's protective order sets forth strict parameters for dissemination of the confidential materials and noncompliance with that order affects the federal interest, the United States is obligated to ensure compliance with the protective order. Should any Massachusetts court authorize the unsealing of the confidential materials in a manner that is inconsistent with the protective order, the United States may need to take appropriate action to ensure that the protective order, as a federal court order, and the United States interests are adequately enforced, which could include removal to federal court of any adverse ruling pursuant to 28 U.S.C. 1442. So what that's saying is that if any state court tries to unseal these materials, not even just tries to unseal the grand jury stuff, if anybody anywhere tries to unseal these federal materials, I mean, they can be given over in discovery, but if anyone tries to unseal them at any point, the U.S. is going to intervene, and if they lose, or if they can't intervene, they're going to just remove it to federal court. To be sure, the United States has no interest in that course of action, particularly that it believes it has provided any material from the confidential materials that could be relevant to the other matters, the Walshe case, etc., as permitted by law, and the parties in the other matter have more than ample publicly available material concerning Proctor's bias as to Ms. Reed. Second, in the United States view, it would be inappropriate for the Norfolk County DA or defense counsel in the other matters, Walshe, etc., to seek to intervene in the U.S. District Court matter and move to amend the protective order. Not only is there no basis for either party to intervene in that federal court matter, but any such motion should be dismissed because the parties have failed to comply with the so-called TUI regulations, 28 CFR 16.21, etc. These regulations, the predecessor of which was upheld by the Supreme Court in U.S. XREL 2 v. Reagan 340 U.S. 462 pin site 468, 1951, I thought it was 85, requires parties seeking federal records to meet certain requirements, including submitting a written demand identifying the specific material sought and its relevance to the proceeding, 28 CFR 1622D. To the extent certain Norfolk County DA's office, assistant DAs, and the defense counsel have submitted TUI requests seeking federal records concerning the Reed matter for use in the other matters, the U.S. has or will consider them in due course. To the extent a party submitting such a TUI request is dissatisfied with the United States response, the only legally appropriate avenue for challenging the U.S. decision is to file an action in federal court under the Administrative Procedures Act, 5 U.S.C. 551, etc., not seek to amend the protective order. Should you have any questions, you can call the U.S. Attorney's Office. So there you go, ladies and gentlemen. I'm going to switch back to the other matter, our other matter, and we're going to watch what's going on in the Donna Adelson case. Oh, okay, so the potential jurors are just being asked their questions now. That was your update on the Karen Reed and John O'Keefe case. I read the full letter. I previewed it for you. I analyzed it. Let's go back to Katie Magbonna's testimony. I need a little bit more time to process that letter. I have to make some calls. I need some time. But I think I know what's going on there. That's pretty interesting. It really shows that we're putting an end to the weaponization of any specters of the federal probe to help other criminal defendants. But what does it mean for Aidan Kearney? That's really what it means. You know, we saw in that statement right there an intent to seek justice against Aidan Kearney. You never are going to get anything too direct in a letter from the U.S. Attorney's Office, but my word, folks. Got a big grin on my face. I'm a little towel. All right, I'll be back for more towel trivia in just about an hour. We're not going to be able to make our originally scheduled 2:45 towel trivia because I had to break in. So towel trivia is going to start, ladies and gentlemen, in roughly 57 minutes. So the next towel trivia round, due to our breaking news, is going to start at roughly 3:10 p.m. All right, 3:10. I'm sorry for the delay. 3:10 p.m. All right, next towel trivia round, 3:10 p.m. Here's the rest of Katie Magbonna's testimony. A lot to think about, a lot to talk about.
Do the right thing.
Yes, sir.
Isn't it because you want to go